Now here's a lawsuit about to happen. The fellow stepping off the sidewalk reading a newspaper has a duty, and he's breaching it. The fellow driving the car also has a duty to keep his car under control, and he may or may not breach that duty. Whether or not there's a lawsuit depends on whether or not the parties can assert one or more causes of action. Every cause of action is nothing more than the right to sue. Some courts allow that certain things are causes of action that they will hear, and some courts won't hear certain causes of action. Common causes of action are breach of contract, negligence, slander. Each of these is the right to sue where there was a duty, someone breached the duty, and the plaintiff suffered damages. There also has to be proximate or direct causation of those damages. Proximate is just a fancy word that says there's a close relationship between the damages and the breach, the cause of the damages being the causation. Now, the thing that we want you to understand about causes of action is that every cause of action that courts hear, such as a case for breach of contract or negligence, has certain elements that must be pleaded and they must be proven. Pleading them is not enough. One must prove what he pleads. If you're the defendant, your job is to show that either the plaintiff didn't plead all the elements of his cause of action, or that he didn't prove them. So an example is a cause of action for breach of contract. In a breach of contract, one must prove and plead that there was a contract, that the defendant breached the contract, and that the plaintiff suffered damages. Now, the existence of the contract can't just be alleged in the sense that there was a contract. What we do in our complaint, and what we fight in the complaint if we're the defendant, is to state the facts that show that there was a contract. For example, the plaintiff and the defendant entered into a contract on such and such a date for the defendant to spray the plaintiff's tomato plants. If there's a written contract, we could also say in our complaint that a copy of that written contract is attached as Exhibit 1, for example. Now we have pleaded the existence of the contract. We may have to later prove that the defendant signed the contract, that it's not a forgery, but at least we've pleaded the existence of the contract, which is one of the elements. We have to plead and prove each of the elements of every cause of action. Another element is that the contract was breached. The contract gave rise to a duty, and if we simply say the contract was breached without saying how the contract was breached, then we haven't done enough, and the defendant could move to have our complaint dismissed. One of the elements is the breach of the contract, and in our little example, we would say that the defendant failed and refused to spray the tomato plants, as he agreed to do in the contract. Now we've pled the existence of the contract by stating the facts of it, and we've pled the breach of the contract by stating the facts of that. Now we also have to plead and prove damages. So the plaintiff would say that as a result of the defendant's breach of the contract, that the plaintiff lost $75,000 worth of tomato plants, for example. Now he has pleaded his damages. He's also going to have to prove these things, but as we say, every element must be pleaded and proved. For a breach of contract, there are three elements that must be supported by allegations of ultimate facts. Now here's another cause of action: intentional interference with an advantage. Usually this is a business advantage or an advantageous business relationship. Now the elements in this case are the existence of an advantageous relationship or advantage, the knowledge on the part of the defendant that there was this relationship or advantage, the intentional and unjustified interference with that advantage, and that the plaintiff suffered damages. These are the four essential elements of the cause of action known as intentional interference with an advantage, or intentional interference with an advantageous business relationship, depending on what they call it in your state. There are the four elements that have to be pleaded, and they have to be proven. The defendant had to know there was a relationship. There had to be a relationship, of course. The defendant had to know there was a relationship, and the defendant had to intentionally and unjustifiably interfere with that relationship. And as a result, the plaintiff says, I suffered damages. And he has to say, I suffered damages in the amount of $17,133 a month, which is what I was gaining from that relationship before so-and-so interfered with it. These things are the elements of causes of action. Slander and libel are another cause of action, whether it's written or spoken. And the elements there are that the defendant caused or communicated an intentional falsehood, either in writing or in speech, that he communicated that falsehood. He knew it was false, and he communicated it to a third party, and the plaintiff suffered damages. Every cause of action that the courts will hear amount to the existence of a duty. The duty was breached, and there were damages. There's nothing more important to understand than causes of action. They are the mechanism of lawsuits. They are the meat and potatoes of lawsuits. They are where you go and what you look for. These are the things that have to be pleaded and have to be proven. Everything that doesn't relate to the cause of action is only in the way. It's causing confusion, and if you're the plaintiff, get rid of it. It's not helping you. But understand that causes of action are at the very heart of every lawsuit, and this is what you look at to win. Whether you're the plaintiff or the defendant, this is where the work must be done.